Hello, everyone. This is Tom Fox, and I'd like to welcome you to episode 109 of the FCPA Compliance and Ethics Report. Today, I visit with Bill Michael, partner at Mayer Brown, on the recent FLIR Systems Securities and Exchange FCPA enforcement action against two individuals. The episode's about 21 minutes. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today it is my distinct pleasure to have Bill Michael, a partner and co-chair of the White Collar Defense and Compliance Group at Mayer Brown. Bill, welcome, and I really appreciate you coming on the podcast.
Well, thanks, Tom. I very much appreciate the opportunity to speak with you about the case.
As Bill alluded to, what I asked him if he could visit with me and us about a recent SEC enforcement action, I think, turned a lot of heads, and that is the FLIR case, if I can call it that. Bill, could you give us a little bit of background into FLIR systems and why you think it's so important?
Sure. I mean, the matter came about last week as a result of an administrative proceeding that the SEC brought against two of the employees of the company. Both of the employees were based overseas, and the SEC sought action against the two individuals for violating the FCPA Act, and at least as to date, hasn't brought any action against the company. And so there's a number of interesting twists with respect to this case, I think, and I think it's an interesting case where, you know, the company found out about this problem in 2009 and started investigating it, and, you know, now 5 years later is kind of the first action against two of the individuals.
Bill, in the SEC press release, it called the one of the key facts or key events that occurred a world tour of for two Saudi government officials paid for by the FLIR individuals in question. Given that statement by the SEC, what did that lead you to conclude about some of the travel they were paying for?
Well, it's interesting that, you know, the SEC looks for little sound bites that certainly drive home the message. And with respect to any sort of business or entertainment travel expenses, a world tour kind of jumps out at you. What was interesting about this case is back in 2009, these two individuals arranged for some Saudi officials from the Ministry of the MOI in Saudi Arabia to travel to different locations. Part of it was to travel to Flir's facilities in Boston, which potentially could, in fact, be a reasonable and bona fide expenditure. But as you mentioned, Tom, about the world tour, what also occurred is a trip to Casablanca, a trip to Paris, not only while in Boston, a trip to New York City, but then a follow-on trip to Dubai and Beirut. And so when you look at the scheme of this, the trip for what could be viewed as legitimate business expenses involved a 5-hour tour of a Flir facility in Boston, and yet the total trip was 20 nights traveling throughout the world.
And that probably goes beyond anything that would be a reasonable bona fide, certainly under the definition of the FCPA. But these two individuals in question actually engaged in conduct that you and I would probably agree is worse than even the travel. I think they gave luxury gifts to the Saudi Arabian officials, and then they tried to disseminate or hide or dissemble, I guess, or hide their actual purpose of their trips and their cost to their company through fabricated invoices.
Yeah, and, you know, what's interesting is, I mean, certainly I think the argument about reasonable and business expenditures is just, it's too difficult to make here. I mean, this is such an extreme. But over and above that, they ended up providing, luxury watches to a number of officials. And then, often, as we all know, the cover-up can be problematic as well. When the company audit raised questions about these things, they attempted to create false invoices and other techniques to try to hide their actions, which, obviously showed a willful intent on their part.
Bill, one of the things I found interesting on the timing of this was right before the holiday season. And I always try to give folks a kind of a review of what's permitted and what's not permitted under the FCPA during the holiday gift-giving season. Using this case as a guideline, can you give some of your thoughts on what might be permitted for a holiday gift or holiday travel or anything along those lines, which might be part of a company's routine businesses?
Yeah, and I think that, you've got different issues, first with respect to travel or with respect to gifts. So, with respect to travel, and this is kind of pretty well laid out, I think, by the resource guide that DOJ and the SEC also issued. But, those types of travel expenditures can be appropriate under the FCPA when, they're actually to visit a company facility, and that it's for, a legitimate business purpose or for training or product demonstration, things like that. One of the big concerns with gift giving, obviously, is the size of the gift and who's getting the gift. Often also one of the things that is appropriate to look at is whether or not it is, routine within the culture. And cultures are changing, as you know, from, all of the publications and media attention to China. What used to be very, very common has now been outlawed by China, so that their officials should not be receiving gifts. But, many cultures, they still look for gifts at appropriate times, and small gifts can certainly be appropriate. I think the SEC has talked about, very small gifts, and I don't think anyone's going to go to jail over promotional pens or hats or things like that. But when you start getting into high dollar values or other things that really have no connection to the company as kind of I call it almost a promotional type gift, it's going to be problematic.
And whatever $7,000 is, I would guess we probably would both agree that doesn't that greatly exceeds any bona fide promotional gift.
Yeah, I think when you look at it, it's the nature of the gift and the circumstances that are going to come into play. Certainly, at least with respect to the FCPA, who the recipient is also a big factor. But yeah, it doesn't take the proverbial brain surgeon to figure out that providing, very expensive watches to the people who are important in decision making on contracts is going to raise significant red flags and probably liability for both the company and the individuals.
Bill, there's one thing that, and one of the main reasons I wanted to visit with you, particularly about this case, is I read a quote where you really identified another issue that I thought was important for the compliance practitioner. And let me just read the quote that was you gave. It is the following: "This case is important as it shows cooperative efforts between U.S. authorities and UAE authorities in investigating the matter, and is yet another recent example of cross-border regulators' cooperative efforts to address global anti-corruption. Additionally, these individuals' efforts to obstruct the company's investigation should and did their personal liability more sanctioned." The cross-border regulators' cooperation is something that is becoming more and more prominent and more important. Could you kind of expand upon your thoughts on that issue for this case?
Sure. So, a long time ago, back when I was with the Department of Justice, the ability to obtain information or evidence overseas was very limited. You had mutual legal assistance treaties, you had letters rogatory, and for the most part, that was it. Nowadays, there have been, an awful lot more cooperative efforts, both formally and informally, in sharing information, whether it's with the UK's SFO or, in this case, as announced through the SEC's press release, the UAE Securities and Commodities Authority. And I think when you look at almost any of the press releases and any enforcement action now, you're seeing a much broader sense of cooperation. And what that does is as we expand into a global economy and companies move from one country cross-border for legitimate business reasons to expand their market or to look for new technologies, they're moving into these emerging areas that don't have the same cultural restrictions on the payments of bribe to, get business moving. And so companies are really challenged by moving in there. And so now you have this much more cooperative investigative process globally. And it really opens up companies to a significantly different risk. So if you think about the FCPA even a decade ago, what you really had to be concerned about was U.S. authorities, the SEC or the DOJ. And, practicing lawyers tend to think of the law as like a chess game. You've always got to be thinking ahead about your, quote, opponent, that is the regulator in this case or DOJ. The reality, though, with all of the more complex issues involving other authorities looking at it, other laws, whether those are blocking laws or state secret laws or data privacy, it's not a chess game anymore. It's three-dimensional chess, because every action you take in any case that you have is going to have implications, with other regulators and other laws in other countries.
I really love that analogy, three-dimensional chess. It's certainly something that I think about, obviously in the FCPA context, because that's my area of specialty. But you have a much broader remit, I would say, within the firm. Could you tell us a little bit about your overall practice in addition to anti-corruption compliance?
Sure. So I spent 10 years as a federal prosecutor with the U.S. Department of Justice, and currently I co-head the white-collar group at Mayer Brown, as well as the global anti-corruption group within our firm. Our firm is a small little 1,500 lawyer law firm with, about 50% of our lawyers overseas. My practice is not really central on any one particular case. I have been involved in securities fraud, internal investigations, healthcare clients, anti-corruption issues, criminal environmental issues, et cetera. So it really is a little more diverse than just any one particular industry.
If I could pick up on a couple of other strands from the case itself that you mentioned in your kind of opening remarks about it, and that was the SEC's use of an administrative procedure rather than going to court to get a cease and desist order or file a civil complaint or a grief injunction, anything like that. Are you in your practice seeing the SEC doing this more? And if so, what implications might it mean for companies in FCPA enforcement going forward?
I have not personally seen an awful lot more, but I do think that especially in cases where, you can work out a resolution, it's a pretty easy resolution. I mean, I've handled these in securities fraud cases previously, and it's one of those things where, in this case, the individuals are, both residing outside the United States. They're clearly subject to this law. They're both United States citizens. they ultimately agreed, and it is a relatively easier proceeding than, bringing things into a federal court. And I think, to expand on this slightly, this is an action against two individuals. Whether or not it expands to an action against the company is kind of unknown at this point. If you look at it, the company has done good things. They investigated it. They continued to dig during it. The SEC order talks about the training that went on. But the reality here is that, this world tour, as it's been described, was approved for payment within the company. And, it in and of itself should have had significant red flags raised because, it's very unlikely that if you're going to send someone to all of these cities, there's going to be a legitimate business purpose behind it. And so when you start looking at these types of expenses, as you would have expected this company to do as they were approving the trip, you wonder who at the company was asking the questions of, well, what's the purpose in going to those other cities? Who's going? How many people? Who selected them? Why 20 days? Why are we only spending 5 hours at, our facility in Boston? And really, who's pushing for the travel? Is it the sales group, or as it was in this case, or is it the operational group about a legitimate purpose? So those are some of the things that I think are going to be interesting as we go forward to see, whether or not this particular company gets sanctioned. But in a broader scheme, to just kind of segue into one other point, I think the SEC and DOJ, in order to more effectively enforce this law, have to be going after more individuals. It's the personal responsibility for these actions that better generates a general deterrent effect worldwide. If a company is sanctioned for the actions of employees, ultimately the entity only operates through those people. And if the entity is sanctioned, the entity and its shareholders are the ones that suffer, not the person who did it. So I think it would be a very real benefit to certainly be looking at holding the individuals more accountable than has been done in the past.
Well, Bill, you have identified many issues that can be used by the compliance practitioner from this case going forward. Really a great analysis of this case. We're unfortunately near the end of our time, but I was wondering if someone wanted to contact you if they had any questions or wanted to follow up, could they shoot you an email?
Absolutely. They can certainly go on the web and find Mayor Brown's website, but my email address is wmichael, and that's MICHAEL, at mayorbrown.com, MAYERBROWN.com, and I'd be happy to take any emails and talk to anyone about either this case or compliance issues in general. I think this is an interesting thing because there are certainly a lot of red flags up front, but it appears the company, did a lot of really good things post-action by the two individuals.
And let me maybe end with one thing that kind of struck me as you were talking through the facts of the case. These events occurred in 2009, and I don't think the press release identifies when the company made the initial discovery of potential illegal conduct, or at least civil violations of the FCPA. But would that sort of be typical for that kind of time frame to reach a resolution?
Well, it's often said, at least by me, that the U.S. government authorities can work at a glacial pace, and in 5 years, certainly is a long time for this. I don't know when the SEC first learned of it. I think if you read the section concerning the administrative order, you can kind of see that it was around March of 2009, perhaps into early April of 2009, when expense reports were submitted for the watches that were given out. And it was July when there was an unrelated review by the company of expenses that kind of led to this. And then the investigation continued from there. So the reality is, even from the order, you can see that the company started having concerns, mid-2009 about this. And again, these cases generally take a long time for a lot of reasons, but this one, for whatever reason, seems to have cracked the 5-year mark.
Well, Bill, unfortunately now we are at the end of our time. I really appreciate you coming on the show and describing this case. A lot for the compliance practitioner, a lot of lessons learned, and I hope companies are paying attention to this because it seems to be pretty significant about what it may mean going forward.
Tom, I appreciate it very much.